sitting session under 25F as if it is written.
Just pause here for a moment, my lord. I'll answer this question of my friend.
My pleading is not over yet.
Just a minute. I'll answer this question of my friend.
Read para 24, 25 and 26, where we raise all the other issues, and then we just mentioned about this issue of robbery of stamp duty. But we have not raised that as a part of this dispute.
The point is this, Manoj, that nowhere have they said that section 25O has to be followed before 25 double F.
Yes,
Now,
yes.
I'll accept that argument. Let us say I'll answer that argument.
Read para 44, which is the last concluding para about our dispute.
34.
Yes.
No, if I may read paragraph 34. In the aforesaid facts and circumstances, the union representing a large majority of workmen is approaching your good self, but an industrial dispute has arisen, and that the same is required to be referred for adjudication. During the pendency of the conciliation reference, the union demands that the workmen staff affected by the transfer of undertakings shall be provided work at continuity of services and full wages from 14/7/2021 to 2020. Whatever it is, one rate.
Yes.
Provided work money shall be paid wages by management. Just a minute.
It
Shall be paid wages by management of Messrs. Century Textiles till they are provided work. The undertaking is closed by following procedure of section 25O.
idea.
The management of Messrs. Century Textiles and Messrs. Manjeet Cotton and Manjeet payments are all allegedly transferred shall not create any charge, interest, encumbrance in the property of the undertaking pending adjudicating the demand.
Adjudication cannot be done by the commissioner.
Can I just?
That's what I was referring to. Judgments.
Now these are, let us assume that these are the reliefs you sought.
Right, next.
These are the reliefs you
D,
sought.
E, and F.
What did you press before the learned single judge? What did you press before the learned single? What is pressed before the learned single judge is born from the order of the learned single judge. And that is in paragraph 10.
They have raised so many grounds.
Plenty of grounds, but what it is, what is
The same.
the law is just a minute, ma'am, just a minute.
One by one, let us understand.
What spells out of the order is what is placed, is argued before the learned single judge. This is the settled law, my lord. So what did you ask now before the learned single judge was the challenge to the transfer of the undertaking. Now let us just say, let us assume that you also press 25O. That I have to comply with section 25O before I comply with section 25 double F. 25O, my lord, for a moment, if we just think is 25O is for closure.
That we have
Yes, ma'am.
the same single.
Now, my lord, closure is a one-time exercise. Let us see section 25O. If I close the undertaking, the chapter is finished.
But you should
It is closed.
without state government's permission. That is our position.
That is the point.
That is legal.
Can I see 25O, my lord?
Yes. So read the MP amendment. No? Read MP amendment to 25O.
Procedure for closing down.
They undertook. Permission, it's a one-time exercise. So once I close, nothing follows after that.
That's important.
And my lord, if we see the closure provision,
The next is
and now let us see section 25F, double F, my lord, as interpreted by the.
There is a मध्य प्रदेश की भी अलग से provision है.
That is, there's only one paragraph is omitted from the central act.
no. There are 9 points.
Yes.
Madhya Pradesh amendment.
There's no difference between the central provision and the state, my lord, except for one provision. And it does not affect my case in the sense.
One paragraph is more.
Well,
It's from Madhya Pradesh.
what is that more, my lord?
Original 25 को देखिए कितने पैराग्राफ है उसमें.
No, my lord, let us see the. Look, it's not relevant. I'm just coming to the point. If my lord may come to see the Maruti judgment now. Maruti.
The issue is whether it is a valid transfer or not.
No, but that cannot be gone into.
And how has it affected the livelihoods?
Under which under this judgment say Supreme Court
Can my lord see?
Harijan क्या नाम है उसका?
That's his my lord.
From that
Next time it should be referred. It should be referred to the Act.
regarding
Because VRS, although they had all accepted VRS,
regarding transfer.
138, and then others also accepted. In our case, about 90% workers have not accepted VRS.
See the one.
The dispute has been raised time and again. And your lordship, that's why I would like to read this. The Madhya Pradesh amendment, only the first para is enough. An employer who intends to close down an undertaking of an industrial establishment to which this chapter applies shall apply for prior permission at least 90 days before the date on which the intended closure is to become effective to the state government, stating clearly the reasons for the intended closure of the undertaking, and a copy of such application shall also be served simultaneously on the representatives of the workmen by registered post with acknowledgement fee. Now, this whole process did not take place, and that's why Supreme Court also compelled them to continue their payment. And they
These are lies, my lord. Blatant lies before this honorable court. Well, these are facts which are taken much before the agreement that was entered into between the petition, the appellant, and the transferee company. What my point is referring to is a Supreme Court order of the date,
2020.
and transfer is taking place in 21.
Yeah, but without following.
This is how the Supreme Court come into play.
So this is no concurrence of the Supreme Court order.
I don't have to case in the industry.
Because two orders have come from this honorable court.
Well, look, there has to be.
Permission given by them, not by us.
Well, look, there's two things to it. One is closure, and one is transfer of undertaking. Two entirely different things. Let us see the Maruti judgment for a moment.
It's not true. Not true at all. I would like also to refer to
Can I take that off?
the same labor commissioner wrote to Century on the 2 days within after they, completed the registries of business transfer, and saying that you cannot resort to 25 FF. So I can refer to that. Those who are the
Can I?
two in our reply.
Let him read this Maruti judgment, then we will see those documents also.
Can
I
I?
will read other judgments.
21.
Dhara.
No.
Which Maruti judgment you're referring to?
This is.
Not giving us a copy of the judgment.
This is.
This is,
It is even the part of record.
what is the page number?
My lord, as paragraph 21, man. How far and to what extent the provisions of section 25F of the 1947 Act would apply in case of transfer of undertaking or closure thereof is the question involved in this appeal. A plain reading of the provisions contained in section 25FF and section 25FFF of the 1947 Act leaves no manner of doubt that section 25F thereof is to apply only for the purpose of computation of compensation and for no other. The expression as if used in section 25F and section 25FFF of the 1947 Act is of great significance. The said term merely envisages computation of compensation in terms of section 25F of the 1947 Act and not the other consequences flowing therefrom. Both section 25F and section 25FFF provide for payment of compensation only in case of transfer or closure of the undertaking. Once a valid transfer or a valid closure is into effect. They're two independent things.
But this is.
That is what they are challenging. They say that
Can I just submit, Manoj? They are asking,
Let
yes.
tribunal adjudicate.
What they are saying is,
The commissioner.
first to comply with section
it's a valid transfer. We can only say
Yes.
अभी देखिए the position is
Your Lordship asked.
no one has decided whether it is a valid transfer or not.
Well, no, that cannot be gone into.
हाँ.
That cannot be gone into. Unless, Manoj, there are ingredients of a sham. We have not, you see the material that is there before the learned, before the commissioner, labor commissioner, it's nothing.
How can it not be? But no, I would like to take some time.
Just a minute.
ये कोई मटेरियल नहीं है तो कोई
Manoj, can I just point out one more thing, Manoj, just one more thing. Now, there's an end, my lord, I am suffering for the last 4, as is, they have admitted it, my lord. For the last 4 years, I'm paying wages to all workmen for sitting at home.
Because it was illegal.
That has run into 100 crores. And my lord has taken,
24 crores.
my lord has taken note of the fact in my lord's order and specifically noted that. what an act it-
में बोला जाता है ना 84 मतलब more than
We have to invest in the machinery. It was not 22 years spent machinery. Total machinery was not. Many machines were purchased 3 years before they closed the mills.
The question is here, my lord.
Saying,
My lord, here we have an issue that whether closure has to be 25O has to be complied with before section 25FF or not. I say, my lord, this 25O is a one-time exercise. Once you close your industry, nothing remains. So there's no question of following 25FF. In 25O, I have to apply with section 25F as if it's a retrenchment. Now, if I can read 25O along with my lord, I'll just point out how the compensation is paid under section 25O.
no, I think that is not to be gone to.
Yes, it is.
Complete your points. You know, you are not allowing me to complete
Just a moment.
the matter.
It's a misleading, that's the point.
Not misleading.
It's a very incorrect statement, that's not correct.
Come on.
Be fair, be fair.
In that Maruti case, this was not an agreement. That 4 years the way was closed
Okay.
without following 25 days.
May I submit one thing?
Kamal
With the
hai.
permission. Yeah, with the permission. So one thing that they have submitted that on page number 326, there was a submission given by us in the Supreme Court regarding compliance of 25O, whereas the submission was given by them and they had sort of correction in the Supreme Court. The application is there filed on their behalf at page number 536. So this was submission given by them that they will be complying with 25O, not by me.
कहाँ description शाम
Because he does not even understand it.
It's
Being used by the owners replaced
No.
by consider.
that's exactly why I need to refer that page number 536, Your Lordship.
So what?
That's an application prepared on their ground, on the grounds of the respondent, stating that however, if the application is filed, so it was not compulsory. It was an option given to me either for 25O or for 25F.
So that's why I was saying, I was going to come to that. 25O is only if I'm seeking to close my industry. And if I close my industry, my lord may see subsection 9. I'm reading the state government, this thing. It's identical to the central government provision, where an undertaking is permitted to be closed down under subsection 3 or where permission for closure is deemed to be granted under subsection 4. Every workman who is employed in that undertaking immediately before the date of application for permission under this section shall be entitled to receive compensation which shall be equivalent to 15 days average of pay for every completed year of service, any thereof in excess of 6 months. So this is as if the person was being retrenched. If we see, my lord, the provision of retrenchment now,
It is not retrenchment.
It's
As if
retrenchment.
retrenchment, as if is the word which is explained in one of the judgments.
subsection 9, subsection
पढ़ना पड़ेगा
subsection 9 of section 25N, that permission for retrenchment has been granted under subsection 3, or where permission for retrenchment is deemed to be granted under subsection 4, every workman who is employed in that establishment immediately before the date of application for permission under
Number 9 in the court schedule. and retrenchment of workmen and closure of establishment. Point 10 in the third schedule. These are definitely the basis. Even compensatory and other allowances. They are saying we did not challenge VRS. We challenge VRS saying, and even in our response we have said it, कि 2 लाख से 25 साल काम किए हुए वर्कर्स को 2 लाख से मैक्सिमम कुछ लोगों को 7 लाख, बाकी 3 लाख 4 लाख ये लेकर वो कैसे जिंदगी जिएंगे? अभी उनका एज बार हो गया तो कैसे हो रहेंगे? तो हमको ये डिस्प्यूट का एडजुडिकेशन चाहिए. And the commissioner's role is not of adjudication. इसके लिए मैं कई सारे आपको कर सकती हूँ.
नहीं वो तो है, वो तो he has to refer
To the this thing. So, yes, but इधर एक ही मैं ये करती हूँ. The definition of industrial dispute is very wide and includes any year Jila Satna Cement Steel Foundry Khadan versus Union of India. Difference between employer and employer or between employers and workmen or even between workmen and workmen which is connected with the employment or even with non-employment or terms of employment. ये dispute है. This is that dispute. And ये मैं कह रही हूँ कि when the commissioner himself wrote letters to them saying that this is fraudulent, this is non-compliance of the orders of the High Court and Supreme Court, how can the same commissioner reject this dispute and not refer to the tribunal to be gone into all the details? And I also said in the beginning itself that the last letter that we have annexed is by the Labour Ministry after the judgment, which is the impugned judgment. Then saying that the उपरोक्त विषय अंतर्गत अध्यक्ष और अन्य श्रमिक संघ द्वारा प्रमुख सचिव महोदय को संबोधित पत्र में सेंचुरी टेक्सटाइल्स की खरगोन के श्रमिकों के हाईकोर्ट इंदौर में चले प्रकरण क्रमांक 28206 में आदेश दिनांक 13/9/2023 का पालन कराए जाने के संबंध में पत्र की छाया प्रति मैं संलग्नकों के प्रेषित है. So the state government now cannot deny it has accepted the judgment which the corporate is challenging. The workers are also accepting the judgment. And there are many judgments which say that adjudication is not to be done by the Labour Commissioner. And they have done adjudication. While they are saying, we have in our reply referred to certain statements which show that it is certainly the adjudication that they have resorted to, Labour Commissioner, which is not to be his role at all. मैं 2-3 वाक्य पढ़ के बताऊंगी. सेंचुरी निर्णय प्रबंधन द्वारा पत्र दिनांक 29/6/2021 के द्वारा स्वैच्छिक सेवानिवृत्ति योजना की पेशकश करने के निर्णय में कोई त्रुटि परिलक्षित नहीं है. Isn't this adjudication? इनको क्या पता है? लेबर कमिश्नर ने कहा यह सब देखा है. दूसरा, उन्होंने ये कुछ थोड़ा सा रेफरेंस किया है पर 25O का फॉलो नहीं हुआ है. ये मुद्दा ही बाईपास किया है सभी ने, इन्होंने भी. दूसरा सर, आपके आवेदन में उनको लिखा है ना, ने मूल रूप से इस तथ्य को इंगित किया है कि सेंचुरी प्रबंधन द्वारा औद्योगिक विवाद अधिनियम की धारा 25A के अंतर्गत शासन से अनुमति प्राप्त करके बंद नहीं किया है. उन्हें कारखाने को राज्य शासन से अनुमति प्राप्त करके बंद करना चाहिए. ये हमारा सेंचुरी प्रबंधन ने अपने जवाब में यह स्पष्ट किया है कि उनके द्वारा कारखाने बंद नहीं किया गया है. कितनी जगह में दिखाऊं, इंक्लूडिंग इन द एनुअल रिपोर्ट ऑफ द CTIM, कि these are in discontinued operations. एंड सेंचुरी ने यहाँ बार-बार कहा है. एंड हाईकोर्ट ने इसलिए मिल खोलो के जवाब दिया ट्राइब्यूनल ने. हाईकोर्ट ने केवल वो मुद्दा नकार दिया तो हम लोगों को सुप्रीम कोर्ट में जाना. तो सुप्रीम कोर्ट ने कहा कि till 25O is followed, they have to continue the payment. तो इसमें और इन्होंने सेंचुरी प्रबंधन ने स्पष्ट किया है कि बंद नहीं किया है. उनके द्वारा औद्योगिक विवाद अधिनियम की धारा 25 के अंतर्गत का स्थानांतरण किया गया है, जिसके लिए परिसंपत्तियों का मूल्यांकन, इसमें भूमि भवन आदि सब सम्मिलित है. कलेक्टर स्टैट से करवाते हैं, स्टैट शुल्क चुकाते, क्रेता को विक्रय किया है. अभी भी है challenges also, but that is in the separate.
ठीक है.
So your lordship, there are number of judgments and we have given a set of judgments.
We have that.
Yes.
This is your bench.
So kindly Telco Convoy Drivers Mazdoor Sangh versus State of Bihar.
Yes.
इसमें आप पैरा 13 and 14 देखिए, पेज 49 पर है हमारे सेट का.
Para 30
Then राम होता है.
and 14.
हाँ. Then राम शर्मा वर्सेस स्टेट ऑफ हरियाणा. इसमें आप पेज 50 में देखिए, तो रोल ऑफ गवर्नमेंट के बारे में है. ये सभी है. और अनकपल्ली में मैं रेफर करके बताती कि what questions they have raised, but these are the main this thing. And it is a settled law that 25 effect cannot be resorted to. When the closure was there, the mills were closed. So it is the same already for years. And they had not followed the Industrial Dispute Act for closure. That is our.
That is her contention, my lord, that it was
Yes.
closed, my lord.
So they just have
She
to.
said it was never closed.
It's our belief.
An application under section 25 was never ever preferred.
Yes.
They
And
never.
25.
So that you continue to make until.
It was a running bill that is valid. Maybe not operations, but
That I can.
maybe
point out-
operations were not in.
I can just
It was
point
not,
out.
it was not a closed mill.
नहीं, सब रजिस्ट्रार का ये है, स्थल निरीक्षण है,
My lord, I need
मिल्स बंद है, दोनों.
a few minutes, my lord, to.
नहीं, एक
My lord, can I, my lord, take it up tomorrow, my lord?
ये लॉर्डशिप जस्ट प्रेयर में मेंशन करती हूँ कि हमारी प्रेयर है कि प्लीज let the order be followed, and now 2.5 months, half months are already passed. So it's almost 10 weeks. While within 6 weeks, they had to comply the order and refer the matter. Now, they themselves, the same labor commissioner gives these two different, this thing. And the state government from the Ministry of Labor gives a separate letter. And here they take a separate position.
ठीक है.
My lord,
Depends on the most fully.
After motion very.
I have to continue. my lord.
Your lordship. I can't come tomorrow. Otherwise, you give us a further date. But I think full hearing has taken.
We cannot give further date. We tend to forget everything. हमको फटाफट लिखना पड़ेगा उसको.
नहीं, आपको ये सब पढ़ना. I request you, your lordship.
Our problem is.
Ji and Hariyanas.
Well,
Otherwise, you have continued for another half an hour. There is no difficulty. This is what they have told me just now. Reminded me. We have to go.
Lordship, my request is that kindly take your time.
Tomorrow, let your counsel be here. You have completed your argument. They want to submit a rejoinder. Let your
Lordship,
for half an hour.
presence. We have not.
Then tomorrow, stay back. What is there?
No, sir, I cannot.
Another case is listed there. Your case is listed in Supreme Court or some other High Court.
the industry has to be closed.
Some other appointment which I cannot change. Otherwise, I would have. Otherwise, let's take the.
Next week, any date?
The next matter is there.
Next week, when we.
Next week is inconvenient because I'm.
Haven't we put?
Will ask for-
What
You may have put your argument. I've still got to present my
is
case.
it that you want to have?
Doesn't have to, it's come back again.
Give us the next date, your lordship.
Madam, we cannot give long dates. Otherwise, you tend to forget everything.
No, not very long. Fifth,
11.
So already cases are lined up.
Yes, on 11th of January.
ये 10th of January.
Not 11th beginning.
January. Why delay so much, your lordship? The workers are without
Well, you
employment.
don't know. बोलिए क्या बता कल तो सुनना तो और
Any date other than
कल
next.
कर रहे थे उसको कल बेटर है
5 तारीख, 6 तारीख कोई भी दे दीजिए.
Just.
नेक्स्ट वीक.
Yes, next week.
Well, can we have it in week commencing? Well, can we have it on 13th or 14th, my lord?
Lordship, Monday.
12th, I'm in last Friday.
Monday and fourth.
I think this is Monday, I'm not, no, Monday, I'm not.
फोर्थ तो नहीं
14th or 15th, December.
The Thursday, 14th December.
Thursday and 15th is Friday.
14th.
Next.
Next time, your lordship, you have a specific time. One is presenting, others are not interested.
After motion hearing only.
My lord, my lord.
But specified time limit. And then we will follow that.
नहीं नहीं एक मिनट आपका arguments over है you can just
It's my rebuttal.
it's not rebuttal.
क्या अभी तक ओवर नहीं है?
अरे मैडम आपको पता नहीं है, पहले पिटिशनर बहस करता है, उसके बाद आपको तो मालूम है यार मोर देन लॉयर नहीं, हजारों केस कर चुके हैं आप।
No, your lordship.
We have been seeing, we have been working with the last so many years. उसमें क्या है?
I just have to give a clarification.
हाँ, just to resolve to your arguments, that's all. Not more than half an hour.
No, that won't take more than that.
Karne counsel to go through all that we have stated.
Yes, yes.
All the judgments of the High Court and not just.
Have already been pronounced a liar. That's.
We are not.
Must have made sense.
The arguments are heard in part. So list this case for further hearing on 15th of December 2023.
Malad.
Are you going to continue?
I am.
Yeah.
Thanks, Malad.
Okay.